Let's take a look at the Fair Credit Reporting Act. Most often, when people think about credit reports, they have in mind information that is gathered about their credit worthiness and used by financial institutions in deciding whether to make loans or offer credit cards. However, credit reports are very broad and are also used by employers in making hiring decisions. The Fair Credit Reporting Act, known as FCRA, is a major federal law regulating the gathering, sharing, and use of information by employers and consumer reporting agencies. It distinguishes two types of credit reports: consumer reports and investigative reports. The FCRA defines a consumer credit report as any written, oral, or other communication of any information by a consumer reporting agency. The report covers a consumer's creditworthiness, credit standing, character, general reputation, and is expected to be collected for the purposes of serving as a factor in establishing the consumer's eligibility for employment purposes. When employers have other firms check into the employment histories, criminal records, licenses, and other information about candidates or employees, they're obtaining a consumer credit report that falls within the requirements of FCRA. An investigative report contains information about character and reputation drawn from personal interviews with friends, neighbors, or other associates. Reference checks performed by third parties qualify as investigative reports. Although these reports may contain financial information such as bankruptcy filing and repayment of loans, they can go far beyond financial matters to reach all other aspects of background checks. For the investigation to fall under the purview of FCRA, the information must be obtained from a consumer reporting agency. This also encompasses companies that perform background checks for employers. The FCRA is responsible for the problem of inaccurate information being gathered and sold about people, resulting in their being denied jobs, mortgages, and other opportunities. It has many detailed provisions. One important requirement is that prospective employers must disclose to a job applicant that a credit report will be obtained and must receive the applicant's authorization to do so on a consent and disclosure form. If, based in any part of the information from a consumer credit report, an employer intends to take adverse action, such as not hiring or promoting, the employer must first provide the individual with a pre-adverse action disclosure. The purpose of this requirement is to provide individuals with notice that negative information about them exists and afford them the opportunity to address possible inaccuracies. However, employers are under no obligation to reconsider a candidate even if erroneous information is subsequently corrected by the consumer reporting agency. Furthermore, the FCRA does not cite any specific period of time that must elapse before an adverse action can be finalized. After taking an adverse action based on a consumer credit report, an adverse action notice must be provided. If the accuracy of a credit report is challenged, a former employer providing the challenged information has an obligation to reinvestigate to confirm the accuracy or the correct information. Reporting agencies are prohibited from including information relating to civil suits, civil judgments, arrests, paid tax liens, accounts placed in collections, and other adverse items of information when it dates back more than 7 years. The FCRA regulates how employers must go about obtaining credit information when third-party sources are involved, but it does not limit the use of such information. At least 10 states have enacted laws prohibiting or limiting the use of such information by employers, although these laws typically make exceptions for jobs in which personal finances might be especially relevant. As with criminal history, the EEOC has taken a keen interest in the potential discriminatory effects of employer reliance on credit information and sued several employers who engage in this practice. The underlying legal theory is that the use of credit history is likely to have a disparate impact on persons of color, and there appears to be little evidence that linking credit history to job performance actually matters. Employers should carefully consider whether to use information about individuals' personal finances in making employment decisions and refrain from doing so if there's not a strong business rationale or job-related reason. We can be more certain that plaintiffs who are not hired because of previous bankruptcy filings will not be able to invoke the protection of federal bankruptcy law. Courts have interpreted bankruptcy code as prohibiting only the termination of such employees, but not as a refusal to hire them.